Hello, welcome to IOS Online Tuitions for Judicial Services. We continue with Section 41 of Indian Evidence Act. Section 41 says relevancy of certain judgments in probate etc. jurisdiction. See, all these come under, what you have to basically remember is, all these come under shall presume of the court. Why is it so? That's because these are all judgments of courts and there is no need to doubt whether the judge has passed it, whether he has jurisdiction. It is not at all necessary. Okay? So, relevancy of certain judgments in probate etc. jurisdiction. Now, when we are talking about probate etc., what we are speaking about is the probate judgment in probate cases, military, so whatever are of special. See, in all these cases you necessarily don't have an opposite party. May be there, may not be there. Okay. So, in all these cases, what is important is, even though it doesn't have any respondent as such, they are also relevant jurisdiction. They are also relevant judgments irrespective of the jurisdiction. As we have seen in CPC, we will be seeing in CPC, CRPC, a judgment which is passed without jurisdiction does not become an invalid judgment just because it was passed without jurisdiction. Okay. So, what is important here is the judgment should have been passed after following the principles of natural justice. Okay. So, when we are talking about this relevancy of certain judgments in probate etc. jurisdiction, even though the court doesn't have any jurisdiction or it has jurisdiction only for a certain type of matters, it doesn't matter, even then it has relevancy. Those judgments should also be presumed to be true. Next we go to section 42. Relevancy of effects of judgments, orders or decrees other than those mentioned in section 41. Section 41, what does it say regarding the probate, military affairs, etc. Okay, so when we are doing this, we know that the judgments are relevant. They shall be presumed provided they relate to the facts in issue and relevant facts. Okay, so when these are there, what about the other judgments? Other judgments also shall be presumed to be true if they are relevant to the facts of the case other than these. Clear? Section 43. Judgments etc. other than those mentioned in 40 to 42 when relevant. See, these are all specific judgments, specific types of cases for which judgments are given. Okay, you can refer to the types of judgments way back in the actual sections which are given. Okay, so in all that, when you are seeing all those pages, you will see the types of judgments which are given there. Just give me a second, I'll give you an example. See, for example, section 41 speaks about judgments in probate etc. When we say probate etc., whatever the judgment which is given in insolvency. Probate is one, insolvency is the other one, matrimonial and admiralty. These are the types of cases which is given in section 41. When we say probate, we know that it belongs to the will. When anyone seeks probate, what are they seeking from the court? Saying that the will is only in my name and not in anybody else's name. Right? So that is P&SE case. That's what we call it as probate and succession case. So it relates to will. When it relates to admiralty, we are all talking about the armed forces. Insolvency petitions, it may go to special tribunals. Matrimonial cases, again it will come only to family court. So as I already told you, these are all the courts which has special jurisdiction. So irrespective of the jurisdiction, when they are passed by these types of courts, then also it becomes a relevant. Other court which is trying a matter which is subsequent proceeding to this shall presume these judgments to be true. Understand? See, for example, I will give you a very simple case where there is a dowry harassment or dowry death or something like that. Let's take dowry harassment because dowry death would not suit this case. There is a dowry harassment case which has been filed by the man or the lady. Mostly it is the lady. Okay. Now this and plus the divorce case has been filed. Now this is going on simultaneously, this is going on, and there is a judgment which has been given saying that the person is divorced. Okay. The judge has passed a judgment saying that the husband and wife are herewith divorced. When this happens, it doesn't mean that the dowry harassment case should also stop, because that is a different thing. So this shall be presumed to be true even though the dowry harassment case is still going on. So when the petitioner or the respondent says we have already been granted divorce by the family court, your honor, that shall become relevant. That shall become relevant and that shall be considered to be true by the court. Okay. Next we go to section 42. 42 is the judgments which are other than those mentioned in section 41. Then we go to section 43. 43, of course, other than those judgments which are mentioned between 40 to 42. Okay. Now we go to the other next one which speaks about section 44. Fraud or coercion. Section 44. Fraud or coercion. Collusion, I am sorry. Fraud or collusion in obtaining judgments or incompetency of court may be proved. Okay. So here what are we talking about? We are speaking about fraud or collusion. In what? In obtaining a judgment. In obtaining a judgment doesn't mean obtaining a judgment as it is. In obtaining judgment in one's own favor. Okay, in one's own favor. Or incompetency of court, where we feel just now we read about jurisdiction. Say for example matrimonial cases. Other than family courts, no other court has the jurisdiction to try family cases. So when we are speaking about jurisdiction, then if a civil court has, for example, passed a divorce judgment of divorce, then it would be an incompetent court. So when we are going further on appeal or revision, anything, when we are going further, if we are putting down the contention that there has been a fraud or collusion in obtaining the judgment by the other party, then we will have to prove it. Okay, only if we prove it, then it will be allowed. See, for example, in some cases appeals are not allowed or second appeals are not allowed. In that case, what happens? If we say there has been a fraud or collusion, your honor, that's why I am filing the appeal, then we will have to prove it. That is why you have the word may be proved, because it is only in certain circumstances that you have to prove such things. Then you have the incompetency, which speaks about the jurisdiction. As I already told you, where it has been passed by an incompetent court. Okay, in that case it has to be proved that the court was incompetent to pass the particular judgment. So where there has been a fraud or collusion or incompetency, it may be proved. Okay, then we go on to the next subheading, opinions of third persons when relevant. Opinions of third persons. We call it as opinions of third persons. You very well know who are third persons. Those who are not related to the suit. They are not party to the suit. Okay, so opinions of third persons when relevant. When will it gain relevancy? In that we read between section 45 to 55. Section 45. Opinions of experts. Now experts are those who are not parties to the suit. We know it very well. So who are experts? First one is they are third persons. Second one is they have special knowledge. About the subject matter. That's why we call it as expert opinion. See, for example, when we file a consumer case talking about some adulterated goods or something like that, okay? Then in that case, we may go either to the consumer court or we may go to the food adulteration tribunal or whoever is the authority. So when we go there, then it will be sent. The sample of the goods will be sent to the lab. Forensic lab. Am I right? There you will get the opinion of experts which says yes, this has been adulterated, no, this has not been adulterated. Right? So that also shall be deemed to be the opinions of experts. So it is not only that it should be written, it can be oral or written or electronic record. This is common for everything, okay? You should remember it. That's it. So this is opinions of experts. Who are experts? Of course they are third persons, but because they have special knowledge, their statements become relevant. They have special knowledge. That is the only thing which makes it as relevant evidence. Otherwise they are they are not at all there in the game. Clear? Then we go to 46 section. What does 46 say? Facts bearing upon opinions of experts. Facts bearing upon opinions of experts. Why is the opinion depending? See, facts bearing upon opinion of expert. When the expert passes a certain opinion, on what basis does he pass? He looks at the facts of the case and then he will come to opinion. Now, which facts does he look at? Obviously, the facts in issue and or relevant facts. When he is looking at the facts, see, just now I told you there is an adulteration. So, he will not see whether who purchased it, from whom it was purchased. Though all those things are written in the petition, that will not be considered by the expert at all. He doesn't need to know who purchased it, from whom he purchased, all these facts. What will he look at? When was the item purchased? Was it adulterated? Simple. Understand? Only these are the facts which he will consider. So facts bearing upon opinion of experts. Opinions of experts will be based on certain facts which will not include the entire facts in issue that we state in the petition or the relevant facts that we state in the petition, not the entire ones. Only those facts which are needed for him to arrive at the opinion. Hope you understood this. We go to the next section, 47. 47. Opinion as to handwriting when relevant. Handwriting. Handwriting, immediately you should understand that we are talking about manual writing. See, when I am teaching you, all these may sound very, we know this. But when you are writing your mains exam, all these will help you. That's why I am so particular when I write certain words. Though you also know it, I also know it. I make it a point to write it so that you can write your mains exam better. You can analyze better, write better, use different words. Okay? So, opinion as to handwriting when relevant. When does it become relevant? When the handwriting is in question. When the handwriting is in question. See, if there is a will which has been typed and the signature is in question, okay, then why will we talk about handwriting? First of all, it is a typed matter. It is not in handwriting. It's not a manual writing. So, we will look at only the signature. If we take up some books of accounts which have been maintained manually, some registers which have been maintained manually, or some FIRs, best example, FIR, it is always handwritten by the writer, am I right? So when we see that, we know the difference in the handwriting. Okay, we can also see the pen with which it was written. There are so many things like that, but here we are speaking only about the handwriting. So let's stick on to that. Here the handwriting, if it differs, then it can be compared to a previous document in which the handwriting was used. Suppose there is a person by name Somaya, okay, and he has written a will. So there is a contention regarding the will in the court. The petitioner says, Somaya is my grandfather, he has written it by hand and all those things, okay. And then there comes a Ramaya. He says, no, your honor, Somaya's handwriting is not this. You look at this letter which he has written to me before his death. His handwriting is this, not this. So where will it be sent? Yes, to the forensic lab for handwriting experts to look at it. Understand? Then we go to the opinion of the experts which we read in the previous sections and all that. Okay, so where the handwriting is in question, handwriting will become relevant. Otherwise, the opinion on handwriting is not at all relevant. Only when it is in question, it becomes a relevant fact. Relevant evidence, I'm sorry. Next, we go to 47A. 47 deals with handwriting. 47A deals with digital signature. All of you must be knowing what is digital signature. We have the IPR, am I right? Intellectual Property Rights. IPR Act, okay. So, when we are talking about this, we know what is digital signature. That the signature which is being used in the electronic media after getting permission or after getting the license from the certifying authority. That is what is digital signature. So when anyone who puts a digital signature, we should know whether the digital signature is of that person or not. Now how are we going to know about it? Digital signature is something, if you have the key of your sister or brother or your boss or your subordinate, if you have the key, then you can use, key is the password, am I right? So you can use the password and enter the digital signature over there. So when the person comes and say, oh no, I did not put this digital signature. Now if it is a manual signature, you can send it to the expert and get the signature verified. But if it is a digital signature, how to verify it? We can only do it from the certifying authority. They will know who has opened when it was opened and all that, but still it is open to loopholes because they will not know who put the password over there. We cannot make who typed the password, we cannot make out that. Certifying authority cannot make out who typed the password because password is supposed to be something which is very secure and all that. So we should not let it out to anybody. So when this happens, digital signature, when there is a question, if the digital signature belongs to the person who has signed it, then it has to be referred to the certifying authority. The certifying authority becomes the expert. In this case, the certifying authority becomes the expert and his opinion will become relevant. Clear? We go on to the next section. Section 48. See, when the questions are being given, you should be very, very open. Okay? Section 48. Opinion as to existence of right or custom when relevant. What are we speaking about here? Opinion. See, all this, the entire subheading deals with when do the opinions of third parties become relevant. That's the question over here. Okay, if you get it in your mains exam, it is very, very easy question. You can handle it very easily. Okay, so opinion as to existence of right or custom when relevant. One thing, yesterday we were doing it. If the opinion has been given by a person who has special knowledge of the right or custom. Second one, it has been given before the dispute in question arose. Right? Opinion as to existence of a right or custom when relevant. When does it become relevant? When it has been given by a person who has special knowledge of the right or custom, saying that yeah, it existed much back, very long back, since long time it has been existent in India or America or whatever it is. Okay, so anyone who has special knowledge about it, need not necessarily be an expert. Anyone who has, see, the person may be a common man, but if such person has special knowledge, then he is deemed to be an expert. There is no need to say that he should have the educational qualification or the experience of the expert. Understand? So anyone who has special knowledge of the existence of right or custom when before the dispute in question arose, and such opinion should have been given before the dispute in question arose, then it becomes relevant. When the dispute is going on, then I pass certainly, yeah, I know, I have heard from my grandfather that it was there since so many years. Will I be called in as a witness? No, because what I am talking about is here. Okay, so anyone who has special knowledge and anyone who has given that statement, that opinion before the dispute in question arose, shall be deemed to be relevant. Okay. Next. 49. Opinion as to usages, tenets, etc. when relevant. See, these are all basically the same thing. Okay? Opinion as to usages, tenets, etc. See, when we say usages, tenets, you can even speak about religious sayings. You can even speak about technical jargons. You know, all those typical words, you know, we as lawyers, we have certain words which only we understand. At least we think only we understand. Say for example, if we are telling something like prima facie, okay, so in that case some common people may understand, some may not understand. Okay, so it depends. Such Latin words or something like that, there are technical jargon. So if you go to the software industry, they have certain jargons of their own. If you go to some scientists, pure sciences, they have certain jargons of their own. So all these technical, whatever are the wordings, then you have all these religious tenets which speaks about so many things. Some of us understand, some of us don't understand. Okay, then you have the usages. In certain areas we have certain, say for example, it can be geographical area, it can be any particular community which does that. Any particular community which does that, or anything like that, any usages, any tenets, any technical jargons, any sayings which we don't understand, everything. When does the opinion become relevant? It becomes relevant again when it is done by anyone who is having special knowledge and such person has given the opinion before the dispute in question arose. But what you should remember, anyone who has special knowledge, when we say special knowledge, what do we mean? It should be by an expert who knows about it. See, if it is, say for example, about some science, okay, and I start giving some opinion regarding some technical words which are used in science. Even though I don't know about it, I have given opinions, okay. In that case, will my opinions be considered? It will not be considered. Why? Because I don't have any special knowledge about it. And probably whatever spoken is also wrong. Okay? So when there is no special knowledge, that will not be considered. And if I am giving an opinion when the dispute is going on, that will also be not considered. So who is supposed to have special knowledge? If it is science, then it will be the scientist. If it is religion, religious tenets, then all these priests, seers, you have so many. Entire India is filled with them. So all these people will be, not everybody, some of them who are very good at it will be called upon to give evidence, or what they have already told, their opinions on that particular subject matter will be taken into consideration. Clear? Thank you.